last week, the Government of India unveiled its latest attempt at data protection legislation. The draft of the Digital Data Protection Bill, Personal Data Protection Bill 2022 is now open for the public comments, and the government is expecting to introduce it in the upcoming budget session. The latest draft is the fourth idea of the data protection law in India. With 760 million active internet users, privacy has remained a thorny issue in India. It was only after the Supreme Court ruled that privacy is a fundamental individual right that the government seems to have given more teeth to data protection. But with the nascent state of India's digital infrastructure, the issue of security and pooling of powers with the centre has raised red flags. To decode the government's agenda, we are being joined by Mr. Rajeev Chandrasekhar, Minister of State for Information Technology. Rajeev Chandrasekhar, really appreciate your time. The simplified 24-page bill has already received a barrage of criticism, I would say, for removing or diluting many of the previously proposed provisions that provided better safeguards to privacy and introducing ones that will do more harm.
Well, I politely disagree, Maria. I think these are all, first of all, I don't think there's been a barrage of criticism. I think there are certain people who have a certain view on what this legislation should be, and they have made their views known to us. This is, as you know, the bill is undergoing consultation, and everybody is entitled to express his or her view on what should be in the bill and what should not be in the bill. As to the point about whether this bill is equal to GDPR, better than GDPR, I want to make it very clear that India is charting its own course in terms of its digital economy. It is charting its own course of framework of laws and rules that we believe are appropriate for our ecosystem and for our people and for our businesses and startups and our government. And so we have absolutely no hesitation in saying that we have never intended to be like the GDPR. We do not want it to be like the GDPR because India is an extremely different digital economy compared to Europe or indeed any part of the world. So we are not in any way hesitating to say that we have charted our own course in terms of what the legislation should be and the framework should be.
Okay, tell me, sir, why does this bill not have the distinction between sensitive personal data and critical personal data? Also, the criticism is on the regulator, that the Data Protection Board is not independent and hence being termed as fully under government control.
So anyway, Maria, first of all, the reason why there is no distinction between critical, sensitive is that we have put all personal data as being equally important. We do not believe that critical data or sensitive personal data should be treated by way of a consumer any differently from the broad swath of identifiable personal data. So we have made it actually better for the consumer by saying that all personal data, it is the obligation of big tech and large companies to protect all personal data of Indian citizens. So there is no attempt at saying you should only protect critical data or you should only protect sensitive data. We are saying for an Indian citizen, all of his or her data is equally important, and therefore it is an obligation of a data fiduciary or a platform to protect that data, and any breach of any data will be a breach under the law. That is number one. In terms of this Data Protection Board regulator argument, Maria, the Data Protection Board is not a regulator. The Data Protection Board under this act does a very specific normal function, very narrow function, which is to adjudicate the damages or the consequences of a breach or a violation of the law by a big tech data platform versus the data principal, the citizen. So this is never meant to be a regulator. It is an absolutely clearly defined narrow functionality of adjudicating disputes, adjudicating the consequences of a breach, and levying penalties on those companies or those platforms that do not fulfill their obligations of protecting consumer data as they have to do under the law.
So what will you tell those who are saying that the government has given itself overriding powers and the individual privacy stands compromised?
Okay, Maria, look, let's be clear that privacy is a fundamental right and which is subject to restrictions. And the restrictions here are very reasonable. The restrictions that the government can use personal data in the event of a security issue, in the case of a issue of a health pandemic, in the case of an issue of a natural disaster. These are all circumstances under which the government can access data, because you cannot be going around at that time and seeking consent of patients or consent of citizens. It's an absolutely very reasonable restriction to the data protection rights of the consumer. And I don't know why people deliberately obfuscate this issue and distort this issue for what it is not. Okay. The government has reasonable rights. Every fundamental right, including the right to free speech, under 19.2, it has reasonable restrictions, and so does the consumer's right to data protection.
Okay, one view is that this data protection bill is expected from a country in the mid-2000s, not the current India. You have tried to be seen as pro-corporate, but the bill actually sets up a huge crisis for India's tech and outsourcing industry. It categorically says that non-residents get no data protection rights.
Maria, look, a lot of this is quite bizarre. I mean, I think these kind of statements are just swinging at a ball and hoping that something will go for a six and hit somebody. But none of these things have any legs to stand on, because this is a bill that makes the misuse of data that is very, very prevalent amongst big tech companies, amongst foreign companies and Indian companies. The misuse of data, misuse of consumers' data will come to an absolute halt, because the consequences of misusing data by corporates is onerous. The financial penalties that are going to be levied on them are going to be significant. So therefore, anybody who's trying to characterize this bill as being pro-corporate or a consequence of corporate lobbying has not understood the bill, has not read the bill. Number one. Number two, we of course are very keen to make sure that no legislation in the digital ecosystem creates a compliance burden, makes it difficult for our young startups and young innovators. This is not an issue that we are shy of saying. We are determined to make sure every legislation in our digital ecosystem, whether they are the IT rules or whether it is the DPDP bill or the forthcoming DIA, further catalyzes innovation, further grows startups and achieves the $1 trillion digital economy that our Prime Minister has set as our target.
Okay. My last question to you, sir. Is this bill consistent with what the Apex Court has ruled, particularly in the context of privacy? You have been a petitioner yourself in the case as a member of parliament.
Oh, absolutely. I can assure you, Maria, that I was one of the petitioners in the Supreme Court when none of these so-called experts who are now commenting on privacy were anywhere in the scene. I fought for privacy, and I believe privacy is an absolute must in this fast-growing digital ecosystem. And this bill meets absolutely the tests of legality, necessity and proportionality that the Supreme Court laid down in the Puttaswamy judgment. It casts reasonable restrictions. It gives the government powers to use data in these exceptional circumstances. It gives the innovation ecosystem compliance not intensive, compliance not heavy legal framework, and it completely puts a stop to the practice of misuse and abuse of personal data by big tech, and protects the data of our Indian consumers in a manner that is modern, that is evolvable, and that as things evolve in the digital ecosystem and more innovations occur, the bill has the ability to evolve and keep in pace with the changes rather than having to be hard-coded and being permanent for today and then having to be changed down the road. So I think this is a modern piece of legislation. This sets the benchmark in terms of how legislation should be drafted and built for the digital ecosystem, the changing ecosystem, and it protects the Indian citizens, it protects Indian business, and I'm very confident that it will be a catalyst for India TechEd mission and vision for us in terms of investments and jobs going forward.
All right. Thank you so much for your time, Rajeev Chandrasekhar. There, this bill, of course, will be tabled in the upcoming budget session of Parliament. The government has put it out in the public domain. There are a lot of criticism that is coming, particularly from multiple stakeholders. That's all from me. Thanks so much for watching.